For our next case, we have the opinion of the Third Circuit Court of Appeals in the case of Surrender Malane versus the United States Secretary for the United States Department of State and the Attorney General of New Jersey. So this case deals with child support. So basically what happened is that a father was ordered to pay child support, and then at some time later he acquired custody of the child, but the state refused to lessen his child support payments even though he had custody, and that would normally be factored in. So the Third Circuit Court of Appeals is being asked to render a judgment as to whether that's proper, so let's see what they had to say in this case. This case arises out of a family law dispute that began in 2011 and remains pending in Hudson County, New Jersey. Over the past 8 years, the family court has required appellant Surrender Malane to pay some $300,000 in child and spousal support to his putative ex-wife, Alina Minova. The crux of Malane's complaint is that New Jersey officials violated his federal rights when they failed to reduce his support obligations after he was awarded custody of their two children and his wife obtained a job that pays more than his own. The district court dismissed the complaint, holding that it lacked jurisdiction under Rooker-Feldman doctrine. And to the extent it had jurisdiction, the district court declined to exercise it under Younger v. Harris. In our view, Malane is entitled to federal court relief and review on some claims, so we affirm in part, reverse in part, and remand for further proceedings. So just by way of background here, when they're talking about Rooker-Feldman doctrine, they're talking about Younger v. Harris, they're talking about cases called abstention doctrine. So there has been in federal law issues where the federal court, even where they have had jurisdiction in the past, have refused to hear certain cases under what's called abstention doctrine. And those relate to cases involving state-level courts and state-level things. So even where a federal government has had jurisdiction in the past, they've often declined to hear the case. Now, this is not much of a thing as it used to be, but these cases are still in the books. So that is basically the issue. Should the district court have refused to hear the case under the abstention doctrine? So the issue isn't, did the district court have the power to hear the case? The issue is, should the district court, notwithstanding have the power to hear the case, not hear the case anyway because of this abstention doctrine kind of stuff? So this is pretty sort of geeky stuff as far as it goes on sort of procedural stuff, and should be really interesting for us to learn something about abstention doctrine law as it relates to the federal courts, both now and in the past. So let's read and see what the federal courts has to say as it relates to abstention doctrine and whether district courts should hear certain kinds of cases, even though they have the power to or not. We first addressed the district court's holding that it lacked jurisdiction under the Rooker-Feldman. That doctrine conflicts with the familiar maxim that federal courts have virtually unflagged duty to exercise jurisdiction conferred by Congress. At the same time, federal district courts are not amenable to appeals from disappointed state court litigants. A litigant seeking to appeal a state court judgment must seek review in the United States Supreme Court. As this court has explained, Roker and Feldman exhibit the limited circumstances in which the court's appellate jurisdiction over state judgments precludes a United States District Court from exercising subject matter jurisdiction in an action it would otherwise be empowered to adjudicate under a congressional grant of authority. Although those limited circumstances arose only twice in the United States Supreme Court, in Rooker and Feldman themselves, lower courts have applied the doctrine liberally for some time. That changed in 2005 when the court decided Exxon. There, the court reversed our expansive interpretation of Rooker-Feldman and confined the doctrine to those cases of a kind from which it acquired its name, cases brought by a state court loser complaining of injuries caused by state court judgments rendered before district court proceedings commenced and inviting district court review and rejection of the judgment. Given those elements, the problem with the district court's application of Rooker-Feldman is readily apparent. Malane does not complain of injuries caused by a state court judgment. In fact, as the district court implied in its order denying reconsideration, there's no judgment at all because Malane is complaining of findings and determination of a family court. But does Rooker-Feldman apply to family courts' interlocutory orders? The answer is less than clear. Before Exxon, we thought Rooker-Feldman barred review of interlocutory state orders that resolved, at least for the moment, the dispute between the parties which forms the basis of federal complaint. Since Exxon, we've now addressed whether Port Authority remains good law, and the decision of our panels and district courts have been inconsistent. Exxon itself offers conflicting guidance. On the one hand, judgment might include non-final orders like preliminary injunctions. That reading would follow the federal rules of civil procedure. On the other hand, Exxon described Ruker and Feldman as cases which the losing party in state court filed suit in federal court after the state proceedings ended. That language suggests Rooker-Feldman applies only to final state court judgments. And the court holding Rooker-Feldman is confined to the cases of kind from which the doctrine acquired its name invites disagreement about the scope of Rooker and Feldman. Fortunately, 6 of our sister circuits have reconciled Exxon's different readings by holding that interlocutory orders are judgments only when they're effectively final. The foundational case in this practical finality approach is the First Circuit. 5 other circuits have cited this with approval. Federation outlines 3 circumstances in which there's a Rooker-Feldman judgment. The first is where the high state court in which review is available has affirmed the judgment below and nothing is left to be resolved. Then the judgment is final judgment or decree rendered by the highest court of a state in which a jurisdiction could be had. The Supreme Court has exclusive jurisdiction in those cases, and state proceedings have ended under Exxon. Second situation in which state action has reached a point where neither party seeks further action. An example is where a lower court issues a judgment and the losing party allows its time for appeal to expire, or the lower state court does not issue a judgment but merely an interlocutory order, and the parties then voluntarily terminate the litigation. In this situation, unlike the first, there's usually not an appealable final judgment or decree rendered. Lastly, there is a judgment where a state proceeding has finally resolved all the federal questions in litigation. Even though state law or purely factual questions remain to be litigated. First Circuit based this scenario on the Supreme Court's second footnote in Exxon. Our holding thus ensures we do not review state court proceedings that have ended, even where the Supreme Court lacks jurisdiction. That satisfies Exxon and limits the interlocutories that count as judgment to those over which the court has jurisdiction. That respects Rooker and Feldman's jurisdictional basis. Applying these principles, we hold that none of the interlocutory orders in the Milan State case are judgments. For one, they're not final judgments or decrees rendered by the New Jersey Supreme Court, nor have they finally resolved all the federal questions and litigations, or has satisfied practical finality under different case law. Milan has several motions pending since 2016. Discovery is incomplete. No trial is scheduled, and the family court has made clear so far that Milan's support obligations will not be changed until a final divorce decree is entered. His state court proceedings are far from ended. Having established the district court had jurisdiction over the federal claims, we consider whether the court erred by abstaining from exercising that jurisdiction. To promote comity between national and state governments, Younger requires federal courts to abstain from deciding cases that would interfere with certain ongoing proceedings. In deciding to abstain, the district court considered 3 factors announced by the Supreme Court in Middlesex County Ethics Committee versus Garden State Bar Association. That is, whether there are ongoing state proceedings that are judicial in nature, the state proceedings implicate important state interests, and the state proceedings afford an adequate opportunity to raise federal claims. But much has transpired since Middlesex was decided almost 40 years ago. In Sprint, the Supreme Court underscored that Younger's abstention conflicts with federal courts' general unflagged obligations to exercise jurisdiction. And just as Exxon and its progeny limited Rooker-Feldman, Spirits narrowed Younger's domain. The court explains, and we have stressed several times since, that 3 Middlesex conditions are no longer the test. Instead, Younger applies only to 3 exceptional categories of proceedings: ongoing state criminal prosecutions, certain civil enforcement proceedings, and pending civil proceedings involving certain orders uniquely in furtherance of the state court's ability to perform judicial functions. Only after a court finds its proceedings fits one of those descriptions should it consider Middlesex's additional factors. Otherwise, divorced from their quasi-criminal context, the 3 Middlesex conditions would extend Younger to virtually all parallel state and federal proceedings. Spirit's first 2 categories do not apply here. None of Milan's count involve a criminal prosecution, nor do any challenge a civil enforcement proceeding akin to a criminal prosecution. Milan's wife, not the state, began the family court case. The case has not sought to sanction Milan for wrongful, enforce a parallel criminal statute, or impose quasi-criminal investigation. Rather, it sought only to distribute its assets equally in the interest of the children and the putative ex-wife. So we ask whether the counts involve certain orders unique in furtherance of the state court's ability to perform the function. Count 2 involves the administration collection of non-final money judgments. It does not challenge how a court protects its status quo pending appeal, as in Pennzoil, when bond money was collateral in lieu of immediate execution, nor does it challenge the process, such as civil contempt, that is separate from the merits and that ends when the defendant complies. In fact, Count 2 does not challenge any judicial order at all. It challenges executive actions that have a layer of family court review. Milan's proceedings are nothing like those of Judas or Pennzoil. The family court vacated its garnishment order last year and has not issued another. No fact finder has returned a verdict. No judgment waits to be entered. So Milan faces only threatened garnishment. Like the plaintiffs in Woodley and Sterrell, he can seek wholly prospective relief. That relief, as pled in count 6, that is the district court declare under Declaratory Judgment Act, the garnishment of custodial parents' wages is prohibited under the Child Support Enforcement Amendments of 1984. Preliminary and permanently enjoin the state's dependent from garnishing the salary so long as he's a custodial parent, and the alternative, grant declaratory and injunctive relief to Milan that state defendants may not garnish payments which are not earnings nor garnish payments above what is permitted by the Consumer Protection Act. On those terms, Milan is not trying to annul the results of a past garnishment, so he may present count 6 in district court. The district court has virtually so that is the end of this case from the Court of Appeals for the Third Circuit dealing with Surrender Milan versus the state of New Jersey as it relates to his child payments and saying the district court could have jurisdiction. So, a pretty interesting case for lawyers as it relates to procedural issues and discussion of these abstention doctrines and relating to the fact that there used to be a lot more on this, but the 2005 case called Exxon changed the balance substantially, as the Supreme Court has the right to do. As a result, the district court can hear this because the preemption doctrines are much narrower than they used to be. So you can go back to district court and try to get some relief there. So all in all, pretty interesting. Helps to inform me a lot as to what's going on in this area of preemption law. Not something I've had to encounter a lot because my field of patent law doesn't have any state law components, so I don't have to worry about preemption law. But it is really interesting to read something and learn a little bit something about federal rules of procedure as it relates to preemption and other kinds of cases. So if you have a state cause of action, you may be able to get to federal court too. So pretty interesting stuff, all things considered.